Today we're going to do a contracts overview. In other words, I'm going to describe to you some of the important features of the legal area of contracts. I'm Professor Capko, and I'm Professor Capko, and I like to take complicated things and make them easy for you. If you like that sort of thing, give this video a thumbs up. It's very much appreciated. I do want to point out in the beginning, my disclaimer, this is not legal advice or accounting advice. It is merely for educational purposes, and you're going to want to get professional help, professional advice if you are entering into contracts. That's always my recommendation. And now, before we go on, I do want to say that I believe something great is going to happen for you very soon. And now, back to the video. Contracts, what are they? Contracts are legally binding agreements. There are certain elements that have to go into a contract to make it a contract, and there are certain things that will happen if parties do not live up to the obligations under the contract. Today's video is just an overview. It's not all the detail. I can do videos down the road. Ha, pun intended. I can do some videos down the road. Ha, how do you like my pun? Where I go into more in-depth on each of these pointers that I'm going to mention. But let's talk about overall what is a contract and what are the elements that make up a contract. Parties make agreements all the time, and whether or not they're legally enforceable, in other words, whether you can enforce them in court or in an arbitration or some other way, is dependent on whether they meet the legal definition of a contract. There are some main elements that you need to have a contract. You have to have offer, acceptance, consideration, and a legal purpose with no valid defenses. Let's talk about those briefly. As I said, I'll do some more videos where we go into more in-depth analysis of them. But an offer is essentially one party saying, this is what I want to do. I want to enter into a contract with you. And do you want to enter into a contract with me? And all they're doing is they're leaving everything to the person that is to accept. That person can either accept the offer or ignore it, reject it, whatever they want to do. But if they do accept the offer, then acceptance is agreeing to the terms of that contract. So they're agreeing to the terms. And depending on the type of contract, it may or may not have to be exactly what was offered. And we'll get into that in another video that has to do with the things called the mirror image rule and the Uniform Commercial Code. I'll talk about those more later. So we have an agreement. Sometimes that's called a meeting of the minds. The parties have agreed to what the contract is going to be about. Next, you have to have consideration. What is consideration? That's a term that's thrown around and people don't necessarily understand what that is. Well, consideration, the legal definition is that it's bargained for legal detriment. That's kind of an overall, what we call black letter law. In other words, basic law school definition of consideration. There's some finer points on that, but overall that's what it would be. So in other words, a party is changing their legal position in reliance upon this agreement, right? So they're agreeing to something and they're changing their position because of this contract. They're changing the legal position. So maybe I am offering to sell you 100 widgets at $20 a piece, and you are agreeing to buy the 100 widgets at $20 a piece. we have each changed our legal position, because once we have this contract, I now have the obligation to deliver to you 100 widgets. And you have the obligation to accept the 100 widgets and pay me $20 a piece. So we've each undertaken an obligation. And that obligation has to be a new obligation. If it is something you were already required to do, then that likely would not be consideration. It has to be a new obligation. So we have an offer, we have acceptance, and then we have consideration. Those are some of the major things that you have to have a contract. Then, obviously, it has to have a legal purpose. You can't have a contract that's enforceable over contraband. You know, I agree to sell you cocaine and you agree to buy it. Well, yeah, people enter into those agreements all the time, and but that would not be enforceable in court. Maybe there's some other enforcement mechanisms in there that are a little bit, shall we say, extrajudicial, but that would not be a contract, because it is not enforceable in court. Likewise, if you entered into or attempted to enter into a contract, if you attempted to enter into a contract for maybe gambling, a gambling contract, you know, you have a gambling debt, and the party to which you owe money to tries to enforce it, and they would not be able to go to court in most states to enforce that, because in most states gambling is illegal, and therefore you cannot make a contract about that. And again, there may be extrajudicial enforcement on that, but that is for another video. Also, you have to have no legal defenses to it. Well, one big legal defense would be, what would people ask? For example, people ask, does a contract have to be in writing? And my brilliant answer is, it depends. It depends. Now, do I tell you that don't make a contract in writing? No. I think the contract should be in writing. But do they all need to be in writing? Well, that is dependent on something called the Statute of Frauds. The Statute of Frauds says certain types of contracts have to be in writing, and I can go into those in another video. But for example, the contract for the sale of land, it would be an example, that has to be in writing. So it has to be in writing. You can't have an oral contract to buy land. There's others, and we'll go into that, like I said, in another video. So Statute of Frauds will determine whether or not the contract has to be in writing. If it is not subject to the Statute of Frauds, then no, it doesn't have to be in writing. So if you're buying something at a garage sale, that's conceivably, that agreement you enter into does not need to be in writing. As long as it's below a certain value, dollar value, your purchase at a garage sale doesn't need to be in writing. Now, can that be enforced? Legally, theoretically, it could. Would it be easy to enforce? No. That's why I said contracts should be in writing, and if at all possible, because why risk it? You know, even if you could have a contract that's not in writing, that's, you know, that could be enforced, you're going to be better off having it in writing. It reduces the possibility of misunderstandings. But it's important to know that contracts don't have to be in writing necessarily, and because you might find yourself in a contract and you didn't realize it. You might say, well, I didn't sign anything. I didn't, you know, that's a common one. I didn't sign anything. But you might have entered into a contract that is perfectly enforceable, dependent upon where it falls on the Statute of Frauds. So be aware of that. If you're agreeing to something and there is consideration, you might have yourself a contract. The other thing to know is there's various laws that determine whether or not something is a contract and how it's treated. The two big differences are something called the common law The common law is kind of law that we have adopted from England when we first became a country, and a lot of contracts revolve around common law principles. Then the other type of contracts are under something called the Uniform Commercial Code. And the Uniform Commercial Code, Article 2 specifically of the Uniform Commercial Code, deals with the sale of goods. The sale of goods. Goods, what are goods? Goods are things that are movable. So, cups, plates, cars, airplanes, boats, anything that's movable. A stereo, an iPad, anything that you can move. It can be tangible or intangible. It is a good. So those things are all governed by the Uniform Commercial Code, UCC Article 2. And the UCC has some different rules from the common law. The common law governs contracts for the purchase and sale of land and or anything dealing with land. Common law deals with anything with land and for services. So services generally fall under the common law. Of course, each state might have additional contractual requirements. That's outside the scope of this video. This is just an overview. So those are some of the key things. And the other thing I was going to say is, what happens if somebody does not live up to the contract? Well, if the contract has to be enforced, if the parties go to court to enforce it, they might have to pay what's called damages. They may have to pay money to the other party for the breach. And another remedy in some circumstances would be called specific performance. In other words, they're going to require you to do something. And that the court would not award damages. They wouldn't award money. They would say, we're going to make you do this. Now, that's limited. That's very difficult to get. And usually it isn't a matter of, we're going to force you to perform a service. Usually it's more in a situation where you're buying something unique. I'm buying a piece of property on a lake. This is the only piece of property exactly like this. And the party who's selling it maybe breaches the contract and says, I'm going to sell it to somebody else. Well, no amount of money is going to make you whole, because no other amount of money is going to give you that piece of property that is unique. So you may be able to get what's called specific performance and make that buyer force that buyer to sell that piece of property to you at the agreed upon price. So I could delve into these more in other videos. If you like this sort of thing, subscribe to my channel and hit the notification bell so you never miss a video. Thank you.